All right, welcome to another video and thank you for coming to my YouTube channel and welcome into sunshine. It's been like 3 days of really bad weather, so I actually have the window open, so I finally got some light here and I can skip the artificial lighting. So now the issue I'm going to talk about today is actually very common. We've all been there at some point, especially when we were younger. And the question actually comes from one of the readers. Now, it was a simple question. Haley was thinking about filing for bankruptcy in Georgia, and she has an issue with the car. Now, as you can see in the title, that can a trustee take a car that's not yours? Yes. I know that sounds a little bit confusing. If it's not yours, how can someone else take it? But when you understand the full facts, you'll see that these are issues that we all have faced. I have faced before title issues, and that's the reality when it comes to a bankruptcy case as well. Now, the facts of this are simple enough, right? This is going to be filed in Georgia, so we have to understand that Georgia exemptions are going to apply. Remember, exemptions is another way of saying protections, right? How much are you protected this particular asset, whether it's your home, personal property, or a car. Every state is different. We're going to go over Georgia in a second, and you're going to see how this really affects the case, where it's going to change everything the way it's going to be. It's going to be handled. Now, Chris, her boyfriend, was doing the right thing. He added Haley to the title because he simply wants to avoid probate. In case something happens to him, good for him. He's thinking ahead. He's thinking, why get a lawyer? Why bother putting this in the will to just to get a car? It makes no sense. It would just make more sense if I had my girlfriend to the title of the car. Absolutely. It makes all the sense in the world. But the reality is, if you ask Haley or anyone else, is that her car? Not really. He just put me on the title in case something happens. But it's not really my car. I don't drive the car. I don't deal with the car. I don't take it in for maintenance. It's not my car. Okay, that's fine. But the law says something completely different. The law is only going to look at title. That's it. That's all the law cares about. So is it Chris's car? Yes. Did he pay for it? Yes. That's the reality. But the second he added Haley to the car, it becomes her car. And that will affect the bankruptcy filing. So if you look at here, we estimate the car is worth $40,000. It's a Chevy Suburban, great car. Once Haley's on the title, $20,000 of that 40,000 belong to her. Now we have the issue of the exemptions. Georgia has a very low exemption. Actually, Georgia has very low exemptions all around. They really don't protect creditors like some state like Texas, California, and definitely Florida. Florida is great with exemptions. Not so much with car exemptions. It used to be 1,000, but guess what? About 2 months ago, it got increased to $5,000. So that will affect the case as well. Now, in this case, Georgia only has a $3,500 exemption. How does exemptions work? Simple. We got to take the 3,500 off of the 20,000 because the first $3,500 are protected. After that, it's not protected. That belongs to the bankruptcy estate. Now, what does that mean with the bankruptcy estate? Well, that's what the trustee is there to protect, right? When you file for bankruptcy, a bankruptcy trustee is assigned. Typically, it's a lawyer, although sometimes some districts have accountants as well. But once the bankruptcy estate has all these assets that are yours, it is the trustee's job to protect those assets. And so, in this case, the bankruptcy trustee is going to say, $16,500 belongs to the bankruptcy estate. How are you going to pay that back? And so that's how you can see how easy a case could get affected. Now, the answer, I know most of my clients would say, oh, I got this. I have this. This is a great idea. I'm just going to transfer. I'm going to transfer the title back. That'll take care of the problem, right? No, you see, wrong answer, buzzard. I had to do that. It's annoying, but I had to get that message across. The reality is you're just creating more of a mess. Either you're going to go forward and file a Chapter 13, and you have to pay back that 20,000 or 16,500 over the next 3 or 5 years, or work out some sort of payment plan with your creditors. But do not transfer the title back. You're only going to make things worse for yourself, and you're going to complicate things even more. You're going to make a mountain out of a molehill. So either you don't file or just go straight to Chapter 13 or figure something else out. But once you start transferring, then you're going to have bigger issues. Okay, so that's what we're focusing on today. As always, if you're one of the paralegals taking my courses, feel free to always make a comment. If you're using my textbook in your course, I always suggest you read the blogs, which will help supplement the material for you. And if you're on social media, come say hi to me. All right, say hi to me in the comments. Say hi to me on Twitter or Facebook, and just check in on me every once in a while, make sure I'm doing okay. If I don't answer, I'm busy making videos. All right. So that's for today's video. I'm done for today, but you see the problem. Before you file for bankruptcy, as a matter of fact, let's skip bankruptcy. Before you make any decision that could affect you legally, I think the right thing to do is always go talk to a lawyer. When I first graduated from law school, I was pending my bar results were pending, and I was working for Lennar Homes, the big nationwide builder. And I was shocked back then in 1999. Homeowners were buying homes worth $500,000, and they did not come with a lawyer to the table. Now they're asking me a million questions, and I don't represent them. I represent Lennar. And so that would create a conflict because they would get upset. And I always ask them the same question: why didn't you just hire a lawyer? And they would say, we didn't want to spend more money. You spend $500,000 and you're not willing to spend another $1,000? That doesn't make sense. And this is a perfect example. I'm glad Haley reached out to me. And if it's not me, definitely speak to a local bankruptcy attorney just to make sure. But a simple little decision that's done with good faith, right? And good faith and honesty. But the road to hell is paved with great intentions, or no good deed goes unpunished. You can see how easy a bankruptcy case could go wrong. And now we're facing issues where that car might be lost unless they can afford to buy back another $16,500 worth of that car. All right, so I'm done for today. If you have any questions, like I said, go ahead and post them in the comments below. And feel free, visit my blog, see what else I've got going out there as well. All right, so it's Monday. Have a good rest of your week, and I will see you at the next video. Take care, everybody.